Thanks so much, first of all, for not just having me at the conference, but including my paper. I'm used to writing pieces that 90% of the legal academy hates, and so I've been starved in this case, because that hasn't been my experience here, so I've been looking for a room where 90% of the people would hate the paper, and I'm grateful to have it. I'm not totally sure what to do with this summary, because I know most of you have read the paper, so I'll just give you one angle into what I was trying to do. In some ways, I hate the paper too, because I am, well, in a number of levels, but even the thesis of the paper, because I'm a kind of old school legal conservative in the sense that I don't like judges to be doing major policy balancing of any sort. It's not that I hate balancing in general. I think all legal norms should be balanced in the sense of being made to serve good ends without intolerable costs. But the question is how much of the balancing will be done ex ante by the people creating the legal norm, and how much will be done ex post by those applying the legal norm, including judges. And I share this current Supreme Court's aversion to balancing, especially in constitutional rights cases, ex post. The court puts that in a couple different ways, most saliently in Bruin, where it says that the whole point of enshrining a constitutional right is to freeze the balance struck by the ratifiers and to impose it on future generations, and if judges balance afresh, they're undoing that. But also a broader concern about the legitimacy of having unelected judges make major moral or policy choices or assessments in these high-stakes settings, pitting individual rights against policies. And I don't think that that kind of thing is inevitable in general in constitutional law. I think the law-politics distinction in that sense is a real one, but I do think it's inevitable for a subset of rights. And it's inevitable not just because the ratifiers happened not to do enough of the balancing up front, but because the very purpose of these rights makes it impossible for them to have done most of the balancing up front. And the easiest way to see that is to think about what the rights I'm talking about, which I call general liberties, and I include free exercise, free speech, and gun rights, what function they serve in contrast to the function that other rights serve. And it's easiest to do that if you think about a single subject matter. So in the paper, I take religious liberty interests. So whatever concerns or values you think are served by protecting religious liberty in various ways, you can imagine a number of different devices for protecting them. So one would just be to write accommodations into each regulation as it arises, but then that's not really going to bind political actors who don't care about religious liberty. They'll just write the regulation to run roughshod over those interests, so then you want to constitutionalize it. But when you constitutionalize it, there's still a couple options. One thing you could do is say, we know and have seen a particular type of regulation that burdens religion, and we don't like it, and we don't want to see it again, and we're going to forbid political actors from imposing it. And an example of that would be the bar on religious tests for office, or even the Establishment Clause as the current court wants to understand establishment. And the drawback of that, of course, is that you can't protect religion against regulatory threats you haven't already seen. And so a third option would be to say, okay, well, we want to protect religion against serious burdens from we know not what future laws. We don't know all the kinds of regulations that will appeal to political actors in the future that might seem necessary, and we want to protect religion against those. So the whole point of a general liberty in that case, something where you say, we're going to protect free exercise or free speech, is to guard against a range of laws that might burden an interest that you cannot foresee. You can't even foresee it to a close approximation, like religious tests for office or anything closely analogous. But that very appeal of these rights, which is to protect against substantially unforeseen threats, also makes it hard to balance in creating the right. Because by definition, you don't know what future regulations it might come to block, so you can't shrink the right to make sure it doesn't block regulations that will prove too important. And the less ex ante balancing is possible with these rights, the greater the need will be to balance ex post. And if the people who gave you the right insisted on making it categorical anyway, then the way to put that is that the greater the pressure will be to balance ex post, despite the way that the right was framed. So I make this kind of practical state of nature thought experiment argument for why it would be hard to do the balancing up front, why it would be inevitable in practice to do the balancing. ex post, and then I try to provide some kind of inductive, historical-ish evidence that it can't be done, which is that it's never been done. It's never been done abroad. All the liberal democracies that enforce rights like this, for the most part, use something like proportionality analysis that involves what I think is balancing in the sense that the current court doesn't like it and that I don't like it. Our early history, according to Judd and to Jamal Green and others, was one where the founders expected there to be substantial regulation of these rights for the sake of the common good, and they just thought the balancing would be done by lawmakers for the most part. And then as soon as courts start vigorously enforcing these rights, again, the general liberties, in this case, free exercise, free speech, and gun rights, you see balancing rise in constitutional doctrine. So Lenakoff's article about it just notices that it happens to arise right when courts are vigorously enforcing these individual rights. And then I think most probative is that even the court that's most motivated and most self-conscious about avoiding balancing in this sense, I think falls back into it, sub silencio or not always very sub silencio, in every one of these areas. And I try to show that by doing a kind of survey of the doctrine, including most recent developments in those three fields. And then I also say something about how, what I think are the best alternatives to categorical application on the one hand or free-form balancing on the other. The best approaches that are trying to avoid those two extremes in their costs, and say why I think they fail, and fail predictably for the same kinds of reasons that, that the initial analysis proposes. And the two approaches that I look at in that vein are, number one, an attempt to reason by close analogical reasoning from some early understandings either of the things that would be protected under the right or of the regulations that would be excluded by the right. And I take Bruin to reflect something like that approach. And I say close analogical reasoning because I think if you allowed your analogies to rely on really broad and sweeping moral or policy considerations, you'd be right back into the balancing that Bruin clearly wants to avoid. But I think that close analogical reasoning approach will run into a dilemma. Either you'll be drawing close analogies to early understandings about what would be protected. So for example, with free speech, you might think, okay, free speech protects against prior restraints and seditious libel regulations and anything very closely analogous to those things. But in that case, you're going to reduce what I was calling earlier the right's open-endedness, its ability to protect against substantially unforeseen threats to the interests in question. And I try to give inductive evidence that our system is very strongly committed to keeping these rights open-ended. So if that won't work, if the close analogies to early protections won't work, then the alternative would be close analogies to early regulations. Okay, so they allowed X, Y, and Z type of gun regulations around the founding, so those and anything closely analogous to those will still be allowed. But I think that would untenably hamstring the government's ability to regulate. So the temptation, whether you start from the rights angle or the regulations angle, will be to ditch close analogical reasoning and rely on much broader criteria for analogy, whether to permitted regulations or to protected conduct. And those broader claims will sweep us right back into what I think the Bruin Court is targeting as balancing. The second approach I consider as a way to try to avoid either categorical balancing that will have untenable categorical application that have untenable costs, or free-form balancing that legal conservatives don't like, is the attempt to list a bunch of to try to do the balancing up front in somewhat more explicit terms. To basically say, look, free speech is protected unless the regulation is serving X, Y, or Z interests. So we told you in advance which interests would be important enough, and so we did all the balancing for you. You just have to apply our instructions. And I think that will run into a very similar dilemma. So either the interests that are stipulated to justify regulation will be defined quite broadly: health, safety, fighting licentiousness, or whatever, in which case it'll be very easy to justify any regulation of the right, which will again make it not open-ended. Or the the interest deemed sufficient to burden the right will be defined very narrowly or concretely, and then again, you'll hamstring the government's ability to regulate in something like the way that people were worried about in Rahimi, where the worry was because the founding era didn't care about domestic violence enough. They wouldn't have had restraining orders or disarmament for restraining orders enough to justify, or anything close enough to that to justify disarming people subject to restraining orders today. So the alternative will be to say, well, okay, it's not just enough to say that the regulation serves public safety or something. It has to serve public safety enough. And that will be right back into the kind of line drawing that I think implicates the concerns that drive this court's critique of balancing, which are, again, concerns that I share at a broad level, even if I think they're inevitable here. Thanks.
So let me first start by pointing out some things that I really agree with in Sherif's piece, and important arguments that I think he's making. He agrees with a distinction I've also made, which is that rights can be either categorical or presumptive. So rights can basically be absolute, where once you fall within the relevant zone of activity, there's not a basis on which government can then interfere with that activity. Or they can be presumptive or defeasible, meaning in certain contexts, government will have a basis to limit that particular activity. He argues, and I agree, and part of his thesis is that categorical rights just can't exhaust the realm of ways in which we protect rights. And I think he also says, and I agree, that even though Bruin sort of presents itself as presenting an option for overriding rights, I think Bruin collapses into being a categorical right, because both step 1 and step 2 are still ultimately questions about does this fall within the relevant zone of activity as a historical matter? We might be asking like a couple historical questions, but they're all questions about, does this fall within the history or not? And if not, if the relevant government regulation doesn't fall in that zone, game over. Government can't regulate that right. And so it becomes categorical in that way. I agree with Sherif that there are some rights that are necessarily open-ended by design. And I think he's also right to point out Bruin, when it chose historical analogs, could have chosen a historical analog of the protected activity or the regulation. The court chose the regulation. That was a decision. That was an act of constitutional construction. It's not as though the Constitution handed that option to the judges. And so to the extent that supporters of Bruin criticize things like strict scrutiny as judge-made law, so was that. That choice was judge-made law. One thing that I want to add to what Sherif says about that is that I think historical analogs at a low level of generality can be really important when we're talking about the protected activity if we want to give categorical protection. And the Establishment Clause is an example of this. But if you are not using the historical analog for the categorical protected activity, if you're using it the other way, then the government has two options, or the court has two options. They can then define the right at a really low level of generality, in which case they have essentially tied the government's hands and prevented them from engaging in relevant modern regulation in ways that will lead to cataclysmic results. Or we can ratchet up the level of generality higher, and then you have sort of boundless judicial discretion. An issue that doesn't exist in the Establishment Clause realm, for example, because the historical analog is telling government this is the limited range of activity is protected, not this is the limited historical range of activity that you can regulate. So I think Sherif also does a good job of showing why Bruin falls on its own sword of a lot of the critiques that it makes, and also why particularly the use of tradition in Bruin is concerning. I think your chess or checkers analogy is a good one, just because at a low level of generality, if you were looking at founding era evidence, if you could only move one spot on the chessboard, that would limit your discretion. If we can look to traditions and say, okay, well, at a low level of generality, this is close to that relevant tradition, which might be very far away from the founding generation, then you've also ratcheted up judicial discretion. Okay, so now I'm going to talk about some of the areas where Sherif and I disagree. One of the things is that Sherif is arguing that as an original matter, by design, the framers anticipated balancing. That's what they thought rights would do, must do. That's how it was conceived at the founding. These are some of his quotes to that effect. The framers would formulate the right to direct its suppliers to balance to avoid costs as they emerge. So first of all, I just think that that's historically inaccurate. And in the piece that I circulated, that Mike kindly circulated, that's the response in the Harvard Law Review, I explain why. Sherif's paper doesn't really do historical work to make this claim. It really rises and falls on the idea that there's no other option. So this was the only way for the framers to make rights open-ended was balancing, so they must have meant that. And I also think that that's false. But let's say that Sherif's right. Let's say that the framers did envision and intend balancing, whatever theory of originalism you want to go with, that's what was understood. Then why critique balancing? Why say we should limit balancing as much as possible? We should embrace popular constitutionalism. If originalism is the idea that we should enforce the original understanding no more and no less than what was intended, then why not have a full-throated embrace of balancing that the framers designed? But Sherif doesn't do that. He walks back from that. He does say, I admit balancing is inevitable for general liberties. I doubt courts can avoid it while remaining the sole enforcers of those rights. I would just add to that, even if Congress does more enforcement of rights, courts will still be doing balancing. So Sherif's solution of let's have Congress do more, which I also agree with and have written about, happy to have him on that bandwagon, doesn't do anything to solve the fact that courts will still be doing balancing. It's not actually responsive to the problem that he seems to think that we have. And so he sort of gives up. Like, should we just do Thayerian deference? Should we say courts are out of the business of protecting rights altogether because we shouldn't balance? Nah, we're too far gone from that. Like, we got to have some sort of protection of things in the Bill of Rights for unknown reasons. And so therefore, we'll just sort of accept that that's what our legal culture is doing. Okay, so this is Sherif's definition of balancing. It's a mouthful. I won't read it to you. But it's very thoughtful. It's a thoughtful definition of balancing. I will note that I don't think it's the standard definition. Sherif says it's required in the literature without citation to that claim. I think it might be true that only you and Justice Kavanaugh adopt this version of balancing, but feel free to tell me if I'm wrong about that. But what I think is, what is excluded from Sherif's definition is it's not balancing if we do line drawing based on neutral benchmarks. So like if we're trying to decide how tall is this tree, there's gonna be a zone that's gonna be hard where there might be vague or the law is in the penumbra. So we'll have to figure that out, but that's not really the type of balancing Sherif's talking about. He also admits that incommensurable balancing is just impossible. So he doesn't defend incommensurability. Okay, so the core inevitability he's concerned about is extra legal determinations, that some applications of the right will be unacceptable, that they cannot be read off legal materials, that these require a fresh moral or policy judgment about the worth of the regulatory goal. Fresh means that the answer to the political moral question is not given in pre-existing materials or requires moral reasoning to infer from them. I'm gonna come back to this. Sorry, this should say three. I really think there might be three definitions of balancing, or three definitions of what Sherif is concerned about, not just one. So the first is conventional balancing, just the idea that you have to put values in relation to one another, and as one value becomes weightier, the other value must also become weightier in order to override it. Analogical reasoning, he's concerned about when it is at too high of a level of generality, when it's not constrained by history. And unacceptable outcomes, he's concerned about a determination that some application would be unacceptable. So part of my point I want to make is that there are areas where all of these would overlap, and there are also areas where none of these would necessarily result in fresh moral legal analysis. So balancing can be something that if Congress told you, judges, in this Constitution, we want you to decide which value will be more costly, that's neither a fresh moral judgment, nor would it be something that would result in incommensurable balancing with sufficient instruction. I think part of the concern is when these things result in the extra legal determination, something that can't be read off legal materials. So the way that Sherif is defining legal materials relies on Larry Alexander's definition of formalism. I hope he's here today. And this is sort of the key claim. Alexander thinks a norm is positive law only to the extent that it can be applied without fresh political moral reasoning. And I think that The first point I want to make is I'm not sure, I don't think that's the correct description of how Larry Alexander is describing law. So he distinguishes between a rule and a standard, and Alexander says that if you had a law, I'm going to use law in quotation marks, that said drive reasonably, then that would just be a standard and it doesn't solve the coordination problems that law is meant to solve. But if the rule said drive reasonably, meaning only take account of conditions related to weather or other drivers, now Alexander says we've come some distance towards being a rule and not being a standard because the lawmaker has told you these sort of moral considerations matter and these don't. That would also be true if the law said drive 55 miles an hour unless it's raining, in which case drive reasonably. And Alexander calls that an impure rule, but a rule nonetheless. It allows some moral reasoning, but it limits your range of discretion of what reasoning is acceptable. Why does that matter? Because I think that Alexander's description of pure rules versus impure rules versus standards, which he describes as a spectrum, is relevant to what Dworkin describes as strong discretion versus weak discretion. So an example I'll use is if there was an officer that told a lower officer in the military, go get Joe to perform this mission. That's a categorical rule. It's a pure rule. We know exactly what to do. There's no discretion. If the officer said, go get your best soldier to perform this mission, there's a lot of discretion involved, but it is not the same amount of discretion if the officer just said, go get a soldier to perform this mission. The last one, it's unlimited discretion. There's no possibility for a mistake. It's a pure act of will for the decision maker to choose which one to do. And I think this is the type of judicial action we should be most concerned about. It's the type of judicial action I'm most concerned about. And I think that that is the type of judicial action that often results when judges are balancing, because it's just a pure act of will. It's also the thing that happens when judges are operating at far too high a level of generality, which is a risk from Bruin. It would also be true if judges just decided on a deontological basis. I think that this result is unacceptable on my own moral view, not Congress's, regardless of the benefits that might come from it or the costs. So that, I think, is the thing at the middle of this Venn diagram that unites some of these issues. But if we could have an approach to rights that leaves them open-ended and has some discretion, but not strong discretion, then I think we should be excited about that. That's the model that I suggest. I won't spend a ton of time on this, but my concern, Sherif, is that your version of my argument is a straw man. It's not the actual argument I'm making, and I want to take some responsibility for this. One of the times Sherif called me to talk about my paper, I mixed up time zones, and I was in the Azores, lost on a back road, dodging potholes, and some hostile cows with service coming in and out. So I don't know what I said on that call. I'm sure it wasn't very helpful. But Sherif has argued that the version of rights I'm proposing is that judges should just decide if a right passes some static threshold of compellingness. And if that threshold stays the same, then it's not balancing, so we're fine. That's really not the argument I'm making. First of all, the only reason I was talking about compellingness is in the context of RFRA. So I said, what do we do about RFRA, which like Congress tells courts to look at whether something is compelling or not? We can't really get around that. At the very least, a compelling interest, I think, should be understood to exclude those reasons like administrative convenience that, if allowed, would defeat a right in any context. That's different than saying, I think judges, in constitutional contexts, if we're going to scratch and figuring out a good test, should just decide if an interest is compelling or not. I think it's a problem for the reasons Sherif suggests. I wouldn't recommend that as a first-order preference. What I do recommend is that if we're like in a context with free exercise, for example, one of the interests that I think is justified for government to limit free exercise, a presumptive open-ended right, is something like public health concerns. And so if you define public health, for example, to mean something like a permanent or lengthy impairment of the normal function of the human body, will we have line, and I'm not saying that's the only definition, but let's just say that's the definition. Will there be line-drawing questions about whether a government's interest falls within that zone in some context that the government has alleged? Yes, but that's different than a court saying, do I think, in my own moral view, untethered from any lawmaker, that this is compelling? I also think that my approach would not result in the level of generality problem you talk about, because under strict scrutiny, especially if we had a more historically modified approach to strict scrutiny, the government will have to allege whatever their level of generality is for public health. So in Holt, the government can't just say, we have an interest in prison security. They have to say, we have an interest in reducing the possibility of prison guards being harmed by inmates who could hide weapons in their beards when this Muslim prisoner asks for religious reasons to have a half-inch beard. Because the reason that the government is asserting has to justify the action that the government wants to take, that is trying to show is in conflict, is in necessary conflict with the right that is meant to be protected. And so when you define the level of generality in the way that the government must to satisfy its evidentiary burden, I think you get out of all of the problems that Sherif is concerned about. I'll go ahead and pause there.
So, okay, just a couple quick points. I agree that you're right that the history claim is not the focus of this piece, and I don't mean any part of it to be load-bearing in that respect. I incorporate by reference everything Judd and Jamal Green and others say, so you're right that it rises or falls with the strength of their arguments. Why critique balancing by judges, or why try to minimize it if I'm right that balancing was required by the original meaning? Well, by the original meaning of the rights. Well, the reason is that while the substance of the rights was originally understood to require balancing, the original understanding as to who would enforce them was that it would be lawmakers and not judges. So if those two things are right, and it's also right that it's too late to just go to non-enforcement by judges, then no alternative available to us now would fully respect originalism. So we're going to be in a second-best world in any event, and then Part 4 tries to sketch away one way to minimize the costs from the perspective of an originalist. The definition of balancing, so I do acknowledge that in the piece that you and Fallon and others in the literature use balancing more narrowly to mean not just any kind of extra legal, political, moral judgment based on broad principles, but cases where such judgments involve just a direct weighing of costs and benefits against each other and asking which is bigger. And I also agree that that form of reasoning faces an objection about incommensurability that other forms don't. And we're sympathetic on the problem of incommensurability. I have a whole dissertation making that argument. But I think the main reason you cite to worry about the incommensurability problem and the main motivation for the conservative legal movement's critique of balancing and emphasis on formalism in the Alexander sense applies to all of the things that I describe as balancing, and for the reasons that I've mentioned. But I agree that strong discretion is one way of putting the thing that creates those concerns. I'll just end on this one thing. So you're right that you don't say that compellingness should be the concept that we use, and that we therefore should draw a threshold to just figure out what's compelling in a way that would raise the policy concerns I'm describing, that would involve judges making policy judgments. But your proposal does involve, I think, exactly the same structure as that kind of determination, because you say, you know, we should the interest that can justify burdens on the right should be defined by reference to the originally understood categories of limitations on the right, like public safety. And the discussion that I had in mind and that I cite when I had in the passage that you cite, was your discussion of Ling, and of a case where, you know, maybe to accommodate a religious claim to use sacred sites on public land, the government could move a highway in a certain way, but it would cost $12.5 million. And you say, well, maybe at that point we can say, okay, avoiding serious costs is a legitimate reason to burden religion, but we're going to draw the line at $12.5 million, and we'll say anything below that is not a sufficient reason. And that's the kind of line drawing that I say involves exactly the kinds of fresh policy judgments not dictated by the legal sources that, and based on broad principles rather than close analogical reasoning, that is the problem. And actually, my response to you on this point was so similar to a response you make to the historical analog approach that I felt the kind of obligation to cite it so that I wouldn't look like I was plagiarizing. Because you say, look, the historical analog approach applied to free exercise would be a problem. Because, for example, there's a case where a woman claimed a religious liberty right to inflict corporal punishment on her child in a way that the state deemed to be child abuse. And the historical analog approach would not allow us to say that the state can burden that religion claim, because there was no historical concern at the founding with child abuse. And if we try to deal with that problem by ratcheting up the level of generality and saying, well, but the founders did care about health and safety, or public safety, I think was the concept you used, then anything can be justified as a matter of public safety, so we'd be right back to balancing. But I think that's exactly true of that claim. I agree with you on that, but I think it applies to this proposal too.
Quick response from Stephanie.
Okay, so on the point about cost, Sherif, the point I was making about the threshold there, it's limited to contexts where, like, at any point could cost become a non-excluded reason if we're taking a protected reason approach to rights. And the argument that I was making is that if political actors have artificially commensurated cost with public safety, they have said at this level, cost becomes so high, we've decided $12.3 million is the cost of a human life. And it's possible that a court could adopt that. And in fact, sometimes in litigation, government will make that argument. And often, in all the cases I've been involved in, the court has rejected it as incredible. But the point is that that's not a fresh policy judgment by courts. That's a policy judgment by political actors that courts could then decide, is that credible in this context? That's different from a court saying, do I think that this is cost enough or not?
So fantastic paper. I asked a variant on this question at many of these, and everybody says, well, you know, that's just a different paper. But 14th Amendment. So I'm curious to what extent you could make a much more straightforward argument just from Corfield. So this language, subject nevertheless to such restraints as the government may justly prescribe for the general good of the whole. So that, you know, that key language, obviously you have all the police power stuff after the 14th Amendment. So just explaining it in those terms, I think the lion's share of these cases involve states. So explaining it in that context would really be helpful. So one way you could do it instead of balancing would be living traditionalism. Count up the number of states that do it. So Bruin, Kavanaugh's concurrence, like, look, 44 states will let you do it. You don't have to balance, just look what the actual pattern is. So if you think a privilege of citizens of the United States, the privilege generally enjoyed today by citizens of the United States, no balancing required, just count up the states. It's dull, there's reasons you might not want to have a provisions like that, but I don't know, talking about that kind of possibility I think would be good. A third thought, I have a question actually for both you and Stephanie. How is your proposal different from Overton Park State Farm arbitrary and capricious review, which I think is one way you could implement an equal citizenship requirement, is requiring an explanation why. I mean, it's a lot like Ling, Overton Park. Why is the straightness of I-40 more important than Overton Park? Why is this road more important than this religious site? Seems like that offers an alternative, but Sherif might think that's balancing. And is this what's the relationship with that to the protected reasons approach?
Yeah, well, thank you for another chance to engage with this paper, Sherif. It's elegantly written and deeply interesting. So you will not be surprised by the comment I make because I've made it before. Let me try again. The title of the paper is Unfinished Liberties, the Inevitability of Interest Balancing. And in the definition that Stephanie put up on the slide, on page 22, the four-element definition, element 4 is explicitly about the balancing of private interests with public interests. But your argument does not show that interest balancing is inevitable. As I think you acknowledge, what your argument shows is that normative rationales of some kind will be required, not that interest balancing is required. Interest balancing has a very old history in American legal theory, going back to Roscoe Pound, And the idea of interest balancing as conventionally understood does not extend to normative analysis of any kind. So I know you are trying to get out of this with a stipulated definition, a second and inconsistent stipulated definition of what balancing is. But I just think that it is irresponsible and that there are problems here with sort of conceptual ethics, clarity, and being responsive to the way terms are understood. And you just don't have the option, as much as you would like it to be the case that the article can be about interest balancing. It isn't. And a stipulated definition that's later taken back just is not a sufficient fix. So I do think it is possible to fix the article, and I think it's possible to do a minimalist fix. The minimalist fix would add something after interest balancing in the title, or other normative considerations. I'm sure you will come up with something very elegant. And then to amend the definition on page 22 so that 4 corresponds to your alternative definitions. And then you can, I think, easily reduce the rhetorical instances of interest balancing in the body of the article. But I really think that if you continue to do what you are doing, you're engaged in a serious ethical lapse as a scholar. You are misrepresenting your argument in such a way that it will just almost for sure be misunderstood as making a claim that you're not in fact making. And I think that's just not good scholarship.
Sherif, I have a two-part question. So first, about open-endedness. I think Wittgenstein taught us that all rules are open-ended. So there are always going to be new applications, or in a way, every application of a rule is new and hasn't been provided for in advance by the rule maker. So it's true you can give someone instructions on exactly how to apply the rule, but those instructions are going to be rules, and so questions are going to arise about how to apply them, and so you can give instructions on how to apply the instructions, but at some point the process has to stop, and you just have to leave the decision maker with discretion about how to interpret and apply the last rule in the series. So Wittgenstein's famous example, which I'm sure you're familiar with, is plus versus quas. All right, if I give you the rule to add 2 to whatever number I say to you, I could give you a lot of examples by way of instruction of exactly how I want the rule to be applied. So I can say, if I say 1, you say 3. If I say 2, you say 4. If I say 3, you say 5. And I keep going all the way up until like 1,000. But if I stop there, who knows? Maybe the way you end up interpreting the rule is to treat add to in the way Wittgenstein defines quad to. You think it means what we would call adding 2 if the base number is less than 1,000, but adding 4 if the base number is 1,000 or greater. So I think that actually all rules are open-ended, and maybe, now you can tell me if I'm wrong, but it seems to me that what you're interested in, and this is actually related to Larry's point, it seems to me that what you're interested in is a particular kind of open-endedness. You're interested in legal rules whose antecedents are like normative or moral propositions, such that the discretion involved in applying those rules to new situations inevitably involves some kind of normative or moral reasoning. Or maybe you do want to make it just about interest balancing, but there's some kind of normative or moral reasoning involved. So first question is, am I right or am I misunderstanding the phenomenon that you're interested in? And then the second part of the question is, if I've got you right, then am I correct in thinking that the phenomenon you're interested in is not limited to the context of rights or liberties and is also not limited to the constitutional context? So two quick examples. The mens rea standard for recklessness is a conscious disregard of a substantial and unjustifiable risk. Unjustifiable that's a moral concept. No instruction is given beyond that to the jury. We just entrust the jury with the discretion to make, to apply that rule and to engage in the moral reasoning required to do so. But that's not really, so it's not a constitutional rule, and it doesn't seem to involve a right or a liberty. One other example, I think it's Federal Rule of Civil Procedure 15, whatever rule governs amending complaints, says something like leave, after the First Amendment as a matter of, you have a right to do that as a matter of course, subsequent amendments should be, leave to make them should be granted, freely granted as the interest of justice so requires, something like that. So again, it seems like we're giving the judge discretion to use moral or normative reasoning about when the rule applies. Maybe it involves a right in this case, a right to amend a complaint, but it's not a constitutional rule. So am I right in thinking that the phenomenon you're interested in is not limited to the constitutional context and is not limited to rights and liberties?
So Chris, the Corfield quote is helpful, thank you. On living traditionalism, I agree that's one alternative approach. And section 4A, which was not assigned for this class, this lecture, Freudian slip, 4B actually, I think, is all about that and about pros and cons of it and why I think it's available, but it's not going to get us all the way there. Arbitrary and capricious review, maybe also related to the Lochner type understanding of applying individual rights. I think that would run afoul of the kind of objections to balancing that I think are similar to the objections to common law reasoning in constitutional law, to like Straussian reasoning, that I think would run afoul of the court's concerns. Larry, first of all, thank you for the earlier engagement too. I hope you could see that a ton has changed in light of your comments in particular, especially at dinner after the workshop. So that was really helpful. I certainly don't want to be unethical if I can avoid it without undue cost. And on balancing, okay, so you have two concerns about the use of the word interest balancing. One is that I give inconsistent definitions for it, and the other is that I hearken to a literature that doesn't actually match what I end up talking about. So on the first point, I want to talk to you about this. I don't actually think it's inconsistent. So the prong 4 of the definition that you're describing on page 22, when it says it's a judgment not guided by prior sources, blah, 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 that either the interest involved is not important enough, or sorry, the individual interest is not great enough to be worth protecting, or that the public interest is, the public cost is too great to provide the protection for the right. And the reason the or matters there is that I'm not trying to limit prong 4 to cases where it's a direct comparison of the one or the other. It could be that the claim that the costs of protection here are unacceptable, it's not saying unacceptable in light of how small the individual interest is. It's just unacceptable on some other grounds. And so it's not the strict commensuration that Stephanie uses balancing to refer to, and that I think you might be saying is inconsistent with the statement in the other part of the paper. But I want to make sure that I want to check with you later. But then on the second point about hearkening to a literature that's not relevant, so I'm getting rhetorical force out of, I take it the claim is I'm getting rhetorical force out of saying, I'm talking about what Roscoe Pound talked about when maybe what I'm talking about is less interesting. I think there's two relevant, salient literatures in some broad sense. There's what Roscoe Pound was talking about and a certain kind of scholarly tradition associated with him. And then there's also what the Supreme Court uses the words to mean. And since the whole piece is framed as a response to Bruen and saying, look, what Bruen wants to avoid, I share that in my heart of hearts, and some of my best friends hate balancing, but actually it's unavoidable. And then I say I'm using it in the sense that Scalia used it in Smith and that Kavanaugh used it here, and then if you're worried about what that means, here's exactly what it means. So I was trying to not steal rhetorical force from Roscoe Pound, but just line up with the very court concerns that I'm directly engaging with. But I also want to talk to you about that, whether you think that's legitimate. And I have no particular attachment to it. I don't actually think because I think I'm responding to what the court's concerns are, I don't think the interest would be deflated if I lost a connection to Roscoe Pound. And I have 5 days to make changes before we enter the dreaded PDF phase of the editing process with the editors. And so I want to talk about ways to not be evil. Charlie, yes, Wittgenstein taught us that everything leaves discretion. I tried to define open-endedness in more determinate terms than that, to say a right is open-ended when it protects against a range of regulations whose countervailing interests can't be foreseen with specificity. So it's a more determinate conception. But you are right that, I think what I just said links up with what you said I really mean. And you're also right that it's not limited, that it shows up in crim with mens rea, and it shows up in all these, except for just cause type exceptions to civil rights, pleading rule, civil procedure pleading rules, and so on. And that's why in the section where I say why this is such a problem for the court and why I share these concerns, I emphasize, and Stephanie does a nice job of emphasizing this, that it's in the, quote, high stakes context of a clash between a democratically supported law and about how the people are going to govern themselves and individual rights. That's where this kind of thing creates special problems.
Chris, really quick to answer your question, how would the protected reasons approach be different from Overton Park and the highway example? So if you have a context where government wants to do highway construction to get a turning lane to reduce the risk of car accidents, and is going to do so in a way that's purportedly going to destroy a Native American sacred site. Overton Park, as far as I understand it, would just say, well, did you look at all the relevant considerations, government? Did you look at the range of options, and then did you act in a reasonable way? And so what I'm proposing is different than that. So let me first really quickly explain what a protected reason is outside the context of rights, because I didn't make that concept up. That comes from Joseph Raz. And he thinks that any law is a protected reason. So before there was a law about speed limits, you already had reasons to drive reasonably. But once there's a law that says you can only drive 55 miles an hour, now you have an independent first-order reason why you should only drive 55 miles an hour. And the law excludes lots of other reasons you might take into account, like, well, I'm running late, or I have a really cool car, it'd be fun to rev the engine. Those are just, they still exist, but they don't get to override the first-order reason of the law anymore. Some reasons might not be excluded, like, my wife is having a baby, so I'm going to go as fast as I want to get to the hospital. And I'm just making the point that I think constitutional rights operate similarly. They provide a first-order reason, one that generally political parties should enforce in terms of why we should give this interest weight. That also means that political parties can't override that first-order reason unless there are other reasons in conflict with it. So I think courts can police, is there an actual conflict here? Or is there an opportunity for a Pareto-efficient opportunity where you could say, widen the highway on the other side of the road and protect the sacred site? We don't need to balance. We can have a win-win opportunity. So courts can look at that. And then they can also look at, was government considering things that should be excluded by this right? And I think that will differ depending on what the right is. And we can ask some specific questions about that. Generally, absent evidence of pretext, I don't think courts should be looking at the internal subjective motivations of government actors. But what they can do is look at, well, what's the official reason that government gave? We need to reduce car accidents. And then, is that reason true? Does that hold up if we look at the evidentiary record? And they are often, I think, courts trying to see if those things align. And that's a much more rigorous approach than just, were you reasonable and did you consider the alternative? If the government was reasonable but they were wrong, then we should rule against the government in that case.
Thanks. Okay, so this word, inevitable. So sometimes when I'm reviewing and editing what I've written, I find that I've made a necessity claim. And I ask myself, did I really want to commit myself to that being necessary? And if the answer to that is no, then quite often I change the word to inevitable. And we also use terms like inevitable and bound to in loose talk in ways that we don't use modal terms. So I might say, oh, it's inevitable that the Chiefs are going to win tomorrow, or the Eagles are bound to lose, right? But I wouldn't say necessarily the Chiefs are going to win tomorrow, or it's not possible that the Eagles will win. So I would encourage you to be clearer in the paper whether you're making just a normative claim, albeit a normative claim that you think is really, really strong and you're really committed to, or whether you want to make a modal claim. If you do want to make a modal claim, it might be good to think about what kind of necessity you're appealing to. And it might be worth looking at a concept that the philosopher Kit Fine pioneered, that others have worked on. There's a bit of a literature in philosophy around this, that he calls normative necessity. So Fine argues that there's something called normative necessity, which differs from both metaphysical necessity and natural necessity. And as I say, there's literature around that, discussing it. I'm not necessarily endorsing it either as a concept or something that's necessarily going to be able to get you over the line in playing this trump card on those who want to argue against you on the normative point. But I think your paper would be clearer if you were, rather than sort of framing it in terms of inevitability, which has the flavor of something modal, but doesn't quite commit you to that, whether it be better just to say, okay, this is a normative argument, or this is a modal argument.
The first point is that quite a few examples of in the paper about inevitability of balancing and sort of the worst balancing examples seem to me obvious examples of non-originalism. So New York Times versus Sullivan, Matthew V. Eldridge based on Goldberg. And then, I think interestingly, Robert Leiter's paper, at least if you thought it exclusive, the common defense, I think would lead to much less, if any, balancing in the Second Amendment. So one point is that, quote, how inevitable balancing is may depend on one's understanding of the rights, and I tend to think that non-originalism has really expanded balancing, and I would like to see more recognition of that. Secondly, sort of related, is that you might think that if we do think that because of the judicial power that balancing is somewhat incongruous with judging, that at least is a reason to not understand rights in a way that create balancing, at least when they're ambiguous. And one could think of non-delegation doctrine, free exercise as ways of, they're plausible ways of understanding them in ways that I think reduce or even eliminate balancing. Third, isn't, if we think of how judges at the time dealt with such matters and rules at the time, should we think about the absurdity rule? So that would suggest, perhaps, that when we do think that rights are indeed categorical, once we get through our sieve that eliminates a good deal of non-originalism, they are very strong, and they are only defeasible if they reach absurd results. And Chief Justice Marshall talks about what absurdity is. It means really everyone agrees that this would simply be absurd. And so that gets us a good deal away from balancing, because it requires not just balancing rights, but a really kind of almost total agreement on that this is absurd.
Sherif, two quick questions. First one more narrow. So you use the ministerial exception as kind of your paradigmatic example of why a right can be categorical, because it's so narrow. I do think lower courts interpret it a little bit more broadly, that it doesn't just apply to anti-discrimination law, and I don't think the Supreme Court has closed the door to that. But what if you were to go a little broader? Because a lot of people would argue that ministerial exception is just a specific application of the church autonomy doctrine, and that is much more broad, and it's categorical. So how does that fit into your paradigm? And then the second question is, I just wonder if there's an additional dimension here. Obviously, that would might be a second paper, but you're talking about the type of right, and therefore, whether balancing is inevitable or it can be categorical. But what about the type of government that the right is invoked against? So against a general government, a government with general police power, that seems like one scenario. But if you have a government of limited enumerated powers, is saying that the type of right therefore requires or is inevitably leading to balancing imply that that government has powers that it actually doesn't have. So anyway.
Great, thank you. So, okay, maybe I should get rid of inevitability and interest balancing, and then I won't have a title to the paper. On page, the likelihood of discretion, exciting. Well, Columbia's stuck already. They have the paper. So on page 9, I say the inevitability claim is not a conceptual claim. It's not a claim that our concept of right and balancing are interdefined or that we can't imagine alternative forms of enforcement. It's about the incompatibility of two goals, which is to avoid ex post balancing on the one hand and have these rights apply against unforeseeably varying laws on the other hand. And then I say in that paragraph, you know, the point of the incompatibility is that it'll either lead to predictably untenable outcomes or it'll lead to, basically that the pressures will be such that we'll always work our way right back to what I'm calling balancing. Now, the inevitability, so it's a practical inevitability in the sense that there's no workable alternative. And that's what I tried to say, but I want to talk about how else I can rephrase that so that it's clear. I agree with you that Kit Fine's concept of normative necessity won't really help here. I think of him there as just saying, he's got his modal categories, there's metaphysical necessity, and then there's necessity under the laws of nature, and then he's just has a separate category for moral claims, the kind of necessity they have, because he thinks that they can vary actually among possible worlds, and I agree with you that in the end won't help me here. John, so I agree with you, many of the examples are non-originalist, and I say at one point at the end of the definition of balancing section, I say, now to say that balancing is inevitable is not to say that every specific doctrine the court has come up with is inevitable. It's just to say, and it's not to say that every application of these rights is inevitable. There can be categorical doctrines that implement them. It's just to say that no rights protections, if it's to be treated as open-ended, will be exhausted by categorical doctrines. But having said that, I mean, my mind changed more over the course of this paper than over any other paper I've written. And one of the examples is New York Times versus Sullivan. So I love the idea that it's made up, it's ridiculous, it's outrageous, like those were the bad old days. But then I thought a little bit more about it and I thought, okay, if I think that the First Amendment protects some right against seditious libel, and I think it doesn't destroy the institution of libel lawsuits, then a line is gonna have to be drawn. And they drew a made up line, but if I'm right that the founders didn't draw the line, then any line that gets drawn will be made up. And so over the time, I came to think, more and more of those precedents are hard to get around. I agree that non-originalism has expanded the balancing, but part of the burden of the paper is to show that no other conception on the table, as long as you think originalism is committed or people are committed to the idea that they'll protect against unforeseeably varying laws, no other way to implement these rights will avoid balancing altogether, or even limit it to marginal cases. I really like the suggestion that the absurdity doctrine could do most of the work in this case. I take people like Scalia's aversion to it to be reflective of the same kinds of concerns about balancing that are driving the other stuff. So I want to think more about, and maybe talk more about whether it can be cabined in a way that would allay some of those concerns. And then James, I agree, the ministerial exception could be a part of a broader thing that, like church autonomy. And it may well be that lower courts are describing church autonomy as categorical. The upshot of the paper is that to the extent that they do treat it as an open-ended thing, even within a limited domain, as protecting against unforeseeably varying laws that might burden a church's autonomy, it will not actually stay categorical. But, in a sense, this is falsifiable. Time will tell.
So I take it to be important to your paper that this doesn't apply to every constitutional right, because you spend a lot of time explaining why it only applies to 3. But why doesn't it apply to other constitutional rights? Isn't even the close analogical reasoning that you want to defend, and even the application of what you call semantic borderline cases, isn't that also the same kind of balancing that you're critiquing? Or that you say is inevitable? And if the response to balancing is politics, then shouldn't we just get rid of judicial review totally?
Sherif, I think about 90% convinced by your paper that balancing is what courts actually do for general liberties. And I'm about 60% sure that that's what they should do when it comes to general liberties, but I'm a little more doubtful about that. I just wanted to wanted to make a couple of suggestions in a friendly vein from someone who's sympathetic to what you're arguing, and also ask a couple of what I think are pretty narrow questions. On the suggestions, I wasn't actually sure, and I think this is in the vein of maybe it was Garrett's question earlier. I wasn't exactly sure what you meant by general liberties until I got to Section 3A, which was the section that lays out early American practice, and does so principally by using the scholarship of Jamal Green and Judd Campbell, and especially Judd's scholarship. So I would suggest, and this may be too much to do 5 days out from your hard deadline, I would suggest trying to move some of that material a little further up just for clarity, and why this is even linked to concerns about the framers. In that vein, whatever you do with Section 3A, I have another suggestion, and that is that I loved hearing from Judd Campbell, and you know, the remarks he makes and that you quote seem to me persuasive, but I wanted to hear more directly from the framers, and I thought it would be useful, especially because I doubted whether the thinking of the framers mapped on to your categories of what are and are not general liberties. So I wasn't quite persuaded by that. Then a couple of small points. I thought I'd also add to Garrett's comment. I don't know why equal protection is kept out of your three categories. It seems to me, yes, it's about the government treating people, targeting people or discriminating in some way in government functions, but at the same time, when the government discriminates against them in the exercise of a liberty, then the government is preventing them from exercising the liberty. And so we have all of these tests, certainly tiers of scrutiny and equal protection that are, as you suggest, are forms of balancing. It's not clear to me really why it should be left out. You've got a couple of sentences in there, but I'm not sure, I wasn't persuaded by that. So a couple of questions, very narrow. At footnote 269 on page 40, you have a sort of continuum or spectrum between what you call finished liberties and general liberties, one being on either side of the spectrum. And I think you identify Griswold as a finished liberty, and then something like a right of privacy as a general liberty. And then I think you place Roe somewhere in between, but more on the side of a finished liberty. I wonder where you would place Obergefell. I suspect, you can correct me if I'm wrong, but I suspect you'd place it on the side of a finished liberty. But I'd be curious about what your response to that is. Some people, by the way, may think it's going to be finished really in about 20 years. We'll see. And then I wanted to ask you about 303 Creative, which has been on my mind a lot over the last couple of years, especially this discussion at 56 and 57 in the paper. Do you think that 303 Creative really creates a categorical rule against speech compulsions? That is, once you find a speech compulsion, you've engaged in that analysis, there's a categorical rule rather than some kind of further balancing a la strict scrutiny or something like that. And I take it you're not sure about the answer to that. At least that's what I pick up from the paper, but maybe I could get you to speculate beyond, because I can't figure the decision out. I can't figure out what the decision is saying about that precise issue. I would like it to say that this is in the nature of a general liberty because it's a speech claim, and that some kind of balancing is going to need to occur even with speech compulsions. But on the other hand, you've got the example of a case, you can't find that anywhere directly in the opinion, and you've also got the example of Hurley, where the court also doesn't mention balancing, and it just seems to follow a categorical rule rather than engaging this balancing. So that's probably more than enough.
you kind of have the vision of a liberty as this, that it protects interests that can't be seen, as you said, with specificity. But the rights are also teleological in a sense. They aim to accomplish certain things. I mean, the Second Amendment spells out what it aims to accomplish. And my question is, how do you avoid the under-enforcement problems here? At what point does it go too far? Because you look at the Second Amendment, there are legitimate reasons to restrict it for public safety. And yet the danger that Bruin's responding to is the fact that the under-enforcement was so pervasive that it had undermined the right entirely. And so I'm wondering, how, in your view, if at all, the courts draw the limits with balancing such that the rights still fulfill their underlying purpose of their codification.
So, Garrett, so yes, it does. No, you're right that it would be really quite too bad for the paper if it turns out this is everywhere. At the same time, I do acknowledge that that these three rights are not the only places that the balancing in this sense shows up. I agree with you that close analogical reasoning involves some political moral considerations, and I just stipulate that out of the definition, partly because I think Bruin does, but also partly because I think there's a difference, not in kind, and I agree with you on that, but in degree. And here I rely on the Sunstein article that Bruin cites as like good kind of analogical reasoning, and saying it's low level, it's focused on particulars, it starts with the facts rather than with abstract moral principles. It prefers under-theorization, et cetera, et cetera. And I agree that's just on a spectrum between the good and bad kinds, but I think it's relevant. The most immediate claim of the paper is that the rights that Bruin points to as involving no balancing and like, why can't you be more like these, which are confrontation and establishment, really do involve significantly less of what I'm talking about. And so it's like but are structurally different. So it's like they're cheating by saying, why can't you be more like this? It's not really an approach. Okay, if the response is politics, why not just get out of judicial review entirely? And I'm stipulating that 80 years of judicial review means it's just too late to go back on that. And I'm sympathetic to the policy concerns that lie behind judicial review, like sometimes majorities don't have the same incentives as unelected judges to protect individual interests and minorities and dissidents. And so I'm just trying to triangulate what's left to us in those cases. Dale, general liberties, I really appreciate the points about foregrounding the definition more, and the other points you made. On equal protection, right, I say defensively, this is probably another paper, and really all I meant to be saying there is, I agree, if you understand it as anti-subordination, for example, and that means no distinctions that are invidious, and that means no distinctions that are not sufficiently justified or something like that, that's balancing. What I suggest at the end is like maybe the court is moving towards a finished account of this, where we read off the history that it's about preventing race distinctions, and we're going to be nearly absolutist about enforcing that, which I think comes out in SFFA. And then I say in conditional form, if you think that's faithful to what equal protection means, or I think maybe if John Harrison is right about what equal protection means, then you could avoid balancing. But if it's just anti-subordination, you can't. 303 creative, does it really create a categorical rule? I agree with you, it's not very self-conscious or clear about exactly what the ratio decidendi is. My main claim there is just that, it's very striking that Justice Gorsuch talks about and makes fun of, quite legitimately makes fun of, the 10th Circuit's application of strict scrutiny, but then does not talk about tiers of scrutiny at all. I think that was deliberate. So I think he's trying to get away he's trying to move towards categoricity. The main claim about 303 is just that that's not going to hold. So if you say, look, just give it time, we can avoid balancing, the court's working on it. I'm saying that the 303 itself contains the seeds of the demise of its own campaign to avoid it. And Robert, yes, these rights have a purpose, and Joel has this great paper defending Bruin where he makes a point, and others have made the point, that you can get some mileage out of that. You can get some categorical grounds for striking down some legislation out of that. And I think actually Bruin and Heller are both good examples of that. I think Bruin could have stopped at saying, this is a right to keep and bear arms for self-defense. It prevents most people from exercising that protected conduct at all, so it's unconstitutional. And whatever test you apply, if it's worth its salt, it would say it's unconstitutional. End of story. And that's kind of what Heller said about the near total ban on having handguns at home. I just think that the overwhelming majority of cases won't involve that, and I think the problems you raise are quite right, which is, for example, we have a doctrine that says dangerous people can be disarmed, and we have a doctrine that says in dangerous places, you can prevent carrying. And we have a doctrine that says dangerous weapons can be banned, which is persons, places, and things. It's like all the nouns. So, and of course, all regulations are about fighting danger if they're about gun regulations. So that's, and then you and Will point out that you could regulate the mode of keeping and carrying arms to prevent, to limit danger. So if all regulations of guns are motivated by a need to avoid danger, then absent the extremes of Heller and Bruin type regulations, you're just going to have to draw lines about how much danger prevention is good enough to justify this kind of burden, and that's balancing.
I'll just raise maybe a small point on the general definition of balancing, and I wonder, you have the part 2 of your definition is determine anew rather than off legal sources, and then on 23 you reject the idea that judges could apply other people's moral reasoning and that would somehow differentiate the determine anew, and your footnote 161. I think that mischaracterizes what Scalia is saying. Scalia is saying that the moral reasoning can't change from the founding generation, but he doesn't say that it matters that it's moral reasoning. And so I think that's just, maybe there's other support that Scalia thinks that too, but I think that's kind of out there and that's more wrapped up in kind of the definition. And I wonder what you think, does it alleviate some of the inevitability if you draw the line there and say, no, it just can't be your own moral reasoning, but you could apply someone else's moral reasoning, and then that's just a factual matter of how would their moral reasoning come out?
Okay, I think there's a deep question here. So let's suppose you're a utilitarian, but you look around and you're John Stuart Mill, but you look around and you say, the founders were not John Stuart Mill. They were natural rights theorists. They were Lockeans. Now you have a case where the application of Lockean moral political theory to this regulation is unclear in the sense that nobody has specifically applied it before. So there's no historical record about what Locke would do. What would Locke do? So now you have to do something new, but it's according to a moral theory that you don't yourself share. Does that involve the kind of discretion that is worrying in this field? And I think you're right that it involves a little bit less in the sense that you're not imposing your own moral theory. You're imposing a moral theory that you think the sources tell you to impose. But it's still not like the kind of formalism that I think Larry Alexander sketches, where you're just following. It's in a limbo in between those things, a twilight zone, where I think some of the concerns still apply.